Thank you very much, sir. Good evening, Conference Chair, Sopali Gunratna, and ladies and gentlemen. The research that I have conducted is titled as A Proposal of Law Reform for the Prevention of Children Being Used for Begging in Streets of Sri Lanka. Within this limited time frame, I will be introducing the four corners of the research and to discuss the main matters in concern. As I move on to the introduction, ladies and gentlemen, as I introduce the people sustaining on the streets, which in similar definition I would like to define as beggars, are a common sight that is to be seen in developing countries and also a problem that is being faced even in the Sri Lankan context. And this has become a well-noticed situation when a child is involved in begging when the adult is also accompanying that child. So the child is basically being used by these adults for the purpose of begging. So, ladies and gentlemen, as the time limits, I would like to point out the research that I have conducted is confined to the law that is in concern for the protection of such children who are at risk. Now, the question poses as to why do we need such an intention of protecting such children, or why does this issue needs to be under spotlight? Ladies and gentlemen, the existing legal framework that is there to protect such children is confined to the provisions of Children and Young Persons Ordinance of number 12 of 1945. While the practical situations of implementation are undergoing due to certain circumstances of protecting these children, it is indeed necessary to make a powerful prevention from a law reform so that they could understand the protection of these children. The research was conducted based on a qualitative method as the methodology, where an informal discussion was conducted with the victims, as I consider the children who are below the age of 18, in certain areas of Colombo and its suburbs, where also a face-to-face interview was conducted with the Child Protection Authority informants and also the probation and child care services to examine the law which is implemented right now. With this, I would like to drag your attention on to the objectives of the research, and that is first to identify the current impact on street children, and thenceforth to identify the protection plan implemented right now by the law in Sri Lanka, and then to find out the reasons why we are proposing a new law reform. When considering the current situation on street children or children who are at risk, I would like to take the definition of United Nations Convention on Rights of Child as the age below 18 years of age. The children have been forced onto the streets mainly due to one reason, as I found through the research, is poverty. And then moving on to that which gives the alternative for the parents of such children to use such children for begging, or else to give that child to special groups who use these children for begging in the streets. Now this points out the violations of these rights of these children, and it's an obvious factor. And most of these groups, you might have even come across, children who are in the hands of these adults are in a silent status that is due to the drugging. Now let's examine the current laws pertaining to the protection of children at risk. As I mentioned earlier, Children and Young Persons Ordinance identified it from section 77 subsection 1, which prevents the habitually wandering vagrants from place to place who's taking a child who's under the age of 5, and this is to be, these such of people are to be punished only if they are being exempted, if they are trying to exempt the child from school or the elementary education. And it follows by the section 77 subsection 2, which allows that any police officer to apprehend such vagrant without any warrant. Now, examining the local legislations, let's now look at the international recognitions or the protection which is established. And that is from UNCRC, Article 19, where Sri Lanka is also a ratified party, and which identify the violations in sales of children and to protect the children in such situations. So if that is the reason, and if the protection is also implemented, why do we need another law reform? And that is to be examined in the next slide, and which I have researched on, to find out the new law reform should be practical, a prohibition, and also specifically the prohibition should be established, and with the effective cooperation of the police and the authorities in concern. The facts and findings of the discussion revealed that adults carrying children on the streets as a result of the inability to accommodate them with proper shelter. This is due to poverty, but this opens up the gate for the parents to give away their child for these organized racketeers who use these children. Now this has become the trend in the current society. You also find out that these children are being used by special group, and the parents are also willingly giving these children to those racketeers to gain money at the end of the day. So it's more as a business. So let me now drag your attention to the third point, which is to say inability to capture such vagrants. It is unable to capture such vagrants in situations, because now let me examine onto the point which established the protection already by the Child Protection Authority. They have established the protection already, as to say, through their child line by 1929, where upon receiving such complaints, they inform the closest police station to go and look for such vagrants and take that child for the needed protection that is needed for the child. Yet the question, a practical issue arises at this point, as to say, the time for the police to reach such vagrants will be quite enough for the vagrant to move from one place to the other. So the capturing of such children has become a practical issue, and it is not implemented by the legislations which is established already. And let me, with due respect to the legislations established, the default in section 77 subsection 1, it addresses only the punishments given for the prevention of children on receiving education. So the legislation established is a mere provision which makes the vagrants preventing children from receiving education. So this cannot be considered a complete prohibition. So the provision here fails to address a complete prohibition. So this is why the research that I have conducted looks on to the new legal reform. And that's where the recommendations from the research is now in concern. Ladies and gentlemen, as I first move on to the first point, which is the recommendations as done from the research, prevention is better than cure. That's how the saying goes. I would believe on the same saying, as to say that prevention of the children who are at risk from being used is always better than finding out ways to punish the perpetrator after the whole situation has already occurred. Well, consider it to be a long-term goal. On the long run, it's going to be a little bit difficult. But yet stick on to the short-term goals of the research, and that is to say that the protection must not confine to the existing provisions. That is pointed out from the second point. That is to say that the responsibility is in the hands of the police from one side, the authorities who are in charge of these protections, and also mainly the public, with their notice of protecting such children who are at risk at this time. And the third point, create a special unit to act effectively upon receiving the complaints. This is the duty of the Child Protection Authority, that is to say that upon receiving such complaints, they should reach the particular place and protect the child and get the child to a safety place. Now, the responsibility from there on is the protecting of the child goes on then to the probation and childcare services. Now, this is a broken up of the chain of whole protection. So, the breaking up of these responsibilities may put the child into a more vulnerable situation which need to be addressed from one particular law. So that's why I recommend creating a special unit to act effectively upon receiving such complaints, so that one will be able to get the needed protection specifically and practically. And the last recommendation, ladies and gentlemen, and that is to say, recommend institutional care. The reason for the parents, the inability to address their needs cannot be the alternative in finding out the streets for the children, to take them to the street. That cannot be the reason. That must not be justified under any circumstances. That's why the reform suggests institutional care, where the government institutions are also established by probation and child care services, and also if the financial assistance is a barrier into that, let's move on to non-governmental organization assistance. On that note, I would like to move on to the final slide, which is the conclusion. The laws created up to date might be definitely indeed sufficient. Yet the problem is in the practical implementation of the existing law. So that is to be addressed by the recommendations, where the recommendations produce what is needed to be done in the time to come. So it brings down to the saying that new reform should be effective and an efficient mechanism to capture the people who carry out child begging, and to create a society where child rights are protected, not confining to the legislation. So on that note, I would like to conclude my presentation. Thank you very much for your cooperation.